Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Previously, I have made a video on OBITER Dicta. OBITER Dicta means passing remark or opinion of the judge. Please remember, this opinion may not form part of the judgment. That means in the judgment, this opinion will not at all reflect, because judges are also human beings. They have also their own opinion. They can express their opinion also. Now and then they cannot sit like Buddha, Mauna Buddha in the seat. Definitely they will get some doubts, they will get clarifications, they may express their opinion also. That expression of opinion is called OBITER Dicta. So another such incident can take place in the recent agitation by the teachers. You may be knowing the PRC controversy. So government says one thing, teachers say other things. On February 20th, there was masquerading of the teachers in Vijayawada. Ultimately, of course, the government has come down to some extent. So in that connection, Mr. K.V.Krishnaraj, he filed a public interest litigation against the state of AP in WP number 1652 by 2022. Right here, the argument started. Then the Advocate General, he has stated that, Your Honor, the matter has been brought to the Constitutional Court. At the same time, these employees or teachers, they want to go on strike. And the matter is sub judice, how can they strike? The strike should be declared as illegal. Either they should go for a strike or they should get the relief from the High Court. Both cannot be clubbed together. But please remember, the OBITER Dicta by the Honorable AP High Court is that, Justice Ahmuddin Aminullah and B.S. Bhanumati, Madam Bhanumati, they stated that approaching the Constitutional Court for the redressal of grievances is ipso facto, that means by itself, would not disentitle a citizen from protesting in relation to the same subject matter. So court has clearly stated that. So you can file a case. At the same time, Article 19, you can have the same freedom of speech and expression, you go for strike also. Both things, don't be under the wrong impression that when you put the matter before the court, you have to wait till the decision. You can go for strike also. This is the observation of the Honorable High Court of EAP while disposing that case. Of course, the case is not disposed, it is posted to some other date, maybe on 17/3 or so. Anyway, luckily, the strike by the teachers has been completed. Now there is no problem. Right? So you can see the citation in Live Law 2022 AP 21. So please remember, a petitioner is not deprived of the right to protest merely because he approached the Constitutional Court on the same issue. Right? No, is it that easy to decide? It is very difficult. Please remember, the Advocate General on behalf of the state, he clearly stated that, Your Honor, how can they go on strike? They do not have any faith in the court. Okay, let them go on strike. If they have got faith in the court, let them wait till the verdict of the court comes. But of course, court did not give any verdict. That is another problem. There is administrative problem. PRC is an administrative issue. Court will say whether the procedure is correct or not. That's all. Court will not give any decision in a particular matter. Same thing is happening. Right? So please remember, previously the Supreme Court, Justice A.M. Khanvilkar, made an observation that a person cannot hold the public protest in a sub judice matter. Here, yes, the contention of the Advocate General is 100% correct as per the judgment, the oral observation by A.M. Khanvilkar. He stated, the justice stated that when the matter is sub judice, how can go on strike? Of course, strike per se itself illegal, and the government will enforce the so-called ESMA, Essential Maintenance Services Act also against the people who go on strike. Strike is basically banned. That's 100% correct. Otherwise, you have to give a notice, I think 6 weeks in advance or something like that. Now, another judge in the Supreme Court itself, S.K. Kaul, he made an observation that the court is not against right to protest, even if the issue is pending before the court. చూడండి, ఇద్దరు రెండు కోర్టులు, సుప్రీం కోర్టులోనే ఇద్దరు జడ్జిలు డిఫరెంట్ ఒపీనియన్స్ ఇచ్చారు. ఖాన్విల్కర్ గారు ఏం చెప్పారు, మ్యాటర్ సబ్ జ్యుడిస్లో స్ట్రైక్ ఎట్లా వెళ్తారయ్యా. సో అలాగే సంజయ్ కిషన్ కౌల్ గారు నో ఓవరల్ అబ్జర్వేషన్ కూడా court is not against the right to protest because Article 19, freedom of speech and expression, right to protest. So kabatti they have got a right to protest even though the matter is pending before the court. So ikkade rendu opinions vachinayi. Which is correct? Court will decide, right? Please remember K.V.Krishnaraj, he filed a writ petition seeking declaration that GOMS number 1/2022, which was issued on 17th January 2022, is illegal, arbitrary and contrary to the provisions of AP Reorganization Act and also according to the Constitution of India. Because PRC normally their salaries should be, there should be some hike in the salaries basing on inflation index. So actually add interim protection or add interim relief of I think 33% has been given. Now they want to reduce it 24 or like that. So how can you reduce the same? Normally you may be knowing, suppose for example in the case of salaries of the judges. So please remember the salaries of the judges, the salaries of the UPSC members, the salaries of the Attorney General, all these people, commission members, all these people, please remember they should be to the advantage of the members, not to the disadvantage. That means you should not reduce the salary. What sin the employees have done? So this is the observation of the High Court. So please remember, but Advocate General, he placed reliance on a case law that is T.V. Rangarajan versus Government of Tamil Nadu 2003. So it says that the government employees have no right, have no fundamental right to go on strike. So when the WP is, the Advocate General Sriram Subramanian, he says that when the WP is filed, it is not proper to go on strike. So now two conflict, these are all, please remember, OBITER dicta, they are not born on record. So these opinions have been, so they said like this and these people said like this, right? So please remember, but what about the High Court of AP? Please remember, AP High Court, it has clearly stated that in the case of Mazdoor Kisan Shakti Sangathan versus Union of India 2018, it was held that right to peaceful protest is recognized as a fundamental right because it is a representative democracy. We are living in a representative democracy. Article 19(1), freedom of speech and expression. So Advocate General says immediately it is not an absolute freedom. It has got the so-called test of reasonableness. So whatever it is, this is all OBITER dicta. Of course, during the regular trial, it will be considered whether Krishnaraj is right or not. I think you might have understood this problem. So please గుర్తుపెట్టుకోండి, ఒక కేసు పెండింగ్లో ఉండగా స్ట్రైక్లోకి వెళ్ళవచ్చునా లేదా అనేటువంటిది దీంట్లో ముఖ్యాంశం. సో మన ప్రభుత్వం ఏం చెప్పింది, అడ్వకేట్ జనరల్ గారు మీరు కోర్టులో వేశారు కదండి, కోర్టు నుంచి వెర్డిక్ట్ వచ్చేదాకా, జడ్జ్మెంట్ చేసేదాకా ఆగండి, అప్పటిదాకా స్ట్రైక్లో వెళ్ళకూడదు, వెళితే ఇల్లీగల్ అని అన్నారు. కానీ సుప్రీంకోర్టులో ఇద్దరు జడ్జెస్ రెండు రకాలుగా చెప్పారు. ఖాన్విల్కర్ గారు ఏమండి మీరు కోర్టులో మ్యాటర్ సబ్జుడిషియల్ ఉండగా స్ట్రైక్లోకి వెళ్ళడానికి లేదు. సంజయ్ కిషన్ కౌల్ గారు అరే అది ఫండమెంటల్ రైట్ అండి, రైట్ ఆఫ్ ఫ్రీడమ్ ఆఫ్ స్పీచ్ అండ్ ఎక్స్ప్రెషన్ ఆర్టికల్ 19 కింద, ఎస్ డెఫినెట్లీ దే కెన్ గో ఇన్, ఇది ప్రొటెస్ట్ అనేది డెమోక్రటిక్ వే కాబట్టి వాళ్ళు స్ట్రైక్లో వెళ్ళొచ్చు, తప్పులేదు అని ఆయన అన్నాడు. సో ఇప్పుడు వెళ్ళొచ్చా లేదా సమస్య అది అయిపోయింది. వెదర్ పిఆర్సీ, ఈ ఇష్యూ ఆఫ్ పిఆర్సీ ఇస్ కరెక్ట్ ఆర్ నాట్ అది ఏపీ హైకోర్టు మనం కూడా మాట్లాడడం జరిగింది. ఎనీవే ది రెగ్యులర్ ట్రయల్ ఈస్ గోయింగ్ ఆన్. ఆఫ్టర్ ది కంక్లూషన్ ఆఫ్ ద ట్రయల్ ఓన్లీ విల్ కమ్ టు నో హూ ఈస్ కరెక్ట్ అండ్ హూ ఈస్ నాట్ కరెక్ట్. సో దిస్ ఈస్, రిమెంబర్, దిస్ ఈస్ ఓన్లీ OBITER dicta. నోటిది ఓలా, నోటితో మాట్లాడటం, ఇది ఇట్ విల్ నాట్ ఫైండ్ ప్లేస్ ఇన్ ది జడ్జ్మెంట్స్. సో ఇప్పటిదాకా నేను మాట్లాడేది కూడా OBITER dicta కింద తీసుకొని, బట్ ఎనీవే సో కేస్ లాస్ గుర్తుపెట్టుకోండి, ఇంపార్టెంట్ కేస్ లాస్. ఎందుకంటే ఈ కిసాన్ మజ్దూర్ కిసాన్ శక్తి సంఘటన, లేకపోతే టీకే రంగరాజన్ వర్సెస్ దట్ ఈస్ గవర్నమెంట్ ఆఫ్ తమిళనాడు 2003, సేమ్ టైమ్ K.V.Krishnaraj మనకు వర్సెస్ స్టేట్ ఆఫ్ ఏపీ, వెరీ లేటెస్ట్ 2022. These three cases, if you are able to refer, definitely you will get enriched of your legal knowledge. With this, I am going to stop. Thank you very much.